I wanted to take a look at, there's this Senate hearing on the Reconstruction and how it affected the freedmen, the quote unquote freedmen of the 5 civilized tribes. And I was watching it earlier and I found it interesting, and it may be hidden. So I just want to make sure that I can archive it where it's easily accessible. All right. So let's get started.
Good afternoon. Welcome to the committee's oversight hearing on select provisions of the 1866 Reconstruction Treaties between the United States and Oklahoma tribes. In the 1830s, the U.S. forcibly removed the Choctaw, Chickasaw, Cherokee, Muscogee Creek, and Seminole nations from their ancestral homelands in the southeast to Oklahoma on the Trail of Tears. At the same time, individual members of the 5 tribes enslaved Black people, continuing to do so through the Civil War. In 1866, the 5 tribes signed treaties with the United States, which further reduced their land holdings and contained provisions about emancipation.
Okay, I want to stop there real quick because this particular senator just said that. Well, let's go back real quick.
Good afternoon. Welcome to the committee's oversight hearing on select provisions of the 1866 Reconstruction Treaties between the United States and Oklahoma tribes. In the 1830s, the U.S. forcibly removed the Choctaw, Chickasaw, Cherokee, Muscogee Creek, and Seminole nations from their ancestral homelands in the southeast to Oklahoma on the Trail of Tears. At the same time, individual members of the 5 tribes enslaved Black people, continuing to do so through the Civil War. In 1866, the 5 tribes signed treaties with the United States, which further reduced.
So he starts this off by saying how the 5 civilized tribes were removed and they subsequently held slaves. And so I find it interesting that the victim sounds like he's trying to make it the 5 civilized tribes.
Their land holdings and contained provisions about emancipation of enslaved peoples who are collectively referred to as the Freedmen. Now, for the first time in the history of the United States Senate, these sovereign signatory tribes, Freedmen, Descendants, and the administration have an opportunity to present their views on the 1866 treaties for the record. I understand and acknowledge that this is a difficult conversation because this issue at its core involves injustices perpetrated by the United States government more than a century ago.
Okay, so he just stated that the 5 civilized tribes is the slaveholder, but then he goes into how this was the United States. But keep in mind, this is about how the 5 civilized tribes held slaves
against both Native Americans and African Americans. It is emotionally charged for many and for good reason, years long, and acknowledge that this is a difficult conversation because this issue at its core involves injustices perpetrated by the United States government more than a century ago against both Native Americans and African Americans. It is emotionally charged for many and for good reason, years-long litigation and disagreement over citizenship status of freedmen descendants among the 5 treaty tribes has divided communities and even divided individual families. But disagreements cannot get.
These treaties divided individual families.
Resolved in silence And so we will soon be hearing from tribal leaders and representatives for each of the 5 tribes who will speak to their nation's treaty provisions with respect to freedmen descendants. Representative Waters, who has fought for freedmen descendants' rights for years, particularly in her leadership of the House Financial Services Committee, as well as Marilyn Vann, whose advocacy through her organization has raised awareness for freedmen descendants of all 5 tribes. And later this afternoon, I look forward to a deeper dialogue with individual leaders of freedmen groups. So it is our goal today to start a respectful dialogue, to listen to different perspectives, both in a formal setting and informally among members of Congress, tribal leaders, and freedmen advocates, and to educate the committee and the public with informed accounts relating to our nation's 2 greatest failures: the removal of Native peoples from their traditional homelands and the enslavement of Black people. Descendants of both, many here today, still carry the pain of those grave injustices. I look forward to a respectful conversation that takes into account the historic importance of this hearing. I'll now recognize Vice Chair Murkowski for an opening statement.
Thank you, Mr. Chairman, and thank you for convening today's very, very important and, as you have noted, a historic hearing. I apologize that I'm not there in person, but COVID is keeping me here in Alaska for this week. The history of the post-Civil War Reconstruction Treaty tribes, the Cherokee, the Chickasaw, Choctaw, Muscogee, and Seminole nations, often referred to as the 5 tribes, and the Freedmen, the lineal descendants of African American slaves owned by the 5 tribes, is part of history that perhaps many Americans are not familiar with, nor do they fully understand. It is a complicated history of injustice and of sorrow for both Indian tribes and African Americans. And as you have noted, Mr. Chairman, this can be an uncomfortable discussion. It can be uncomfortable to talk about what was brought on by the federal government's own policies of forced removal of Native peoples from their ancestral homelands and the enslavement of African peoples. I understand that each of the 5 tribes has a very unique history with freedmen based on separate treaties with the United States. So
I'm still trying to figure out how the forced removal of the 5 civilized tribes created slavery within them. But let's keep going.
Interested in learning more about what these treaties entail and the obligations of both the tribes and the federal government to freedmen descendants. So I do want to say how appreciative I am that the Indian Affairs Committee is examining this history, and that the 5 tribes and the freedmen descendants are here, along with the Department of Interior, to have a constructive and, again, a respectful dialogue about how we might move forward together. This is indeed long, long overdue. I agree with the chairman that we should task the GAO, the Government Accountability Office, with investigating what federal services the freedmen receive and should receive in the future from the federal government. And with that, I turn back to you, Mr. Chairman. Again, thank you for convening this very important and very substantive hearing. And for the many witnesses that are there in person today, thank you for traveling to be before the committee on a very important topic. Thank you, Mr. Chairman.
Thank you very much, Vice Chair Murkowski, and we wish you
to be known as the Native American freedmen and the ongoing plight of their descendants. The freedmen were Black individuals.
And we look forward to your remarks. Please proceed with your testimony.
Thank you very much, Vice Chair Murkowski and members of the committee. Today, I'm here to discuss an issue I care very deeply about, but has been ignored for far too long. Many remain unfamiliar with the history of those who came to be known as the Native American freedmen and the ongoing plight of their descendants. The freedmen were Black individuals who were enslaved by 5 formerly slave-holding tribal nations and were forced to walk and suffer on the Trail of Tears alongside their slave masters. A year after the Civil War ended, the 5 tribes agreed to abolish slavery and accept freedmen and their descendants as full tribal citizens under the 1866 treaty agreements they made with the United States government. Specifically, the 1866 treaties required the 5 tribes to abolish slavery and to agree to treat and accept formerly enslaved individuals and their lineal descendants as equal tribal citizens. For example, the treaty signed by the Cherokee Nation reads, and I quote, "All native-born Cherokee, all Indians and whites legally members of the nation by adoption, and all freemen who have been liberated by voluntary act of their former owners or by law, as well as free colored persons who were in the country at the commencement of the rebellion and are now residents therein, or who may return within." The treaty signed by the Cherokee Nation reads, and I quote, "All native-born Cherokee, all Indians and whites legally members of the nation by adoption, and all freemen who have been liberated by and their lineal descendants as equal tribal citizens. For example, the treaty signed by the Cherokee Nation reads, and I quote, all native-born Cherokee, all Indians and whites legally members of the nation by adoption, and all freemen who have been liberated by voluntary act of their former owners or by law, as well as free colored persons who were in the country at the commencement of the rebellion and are now residents therein, or who may return within 6 months from the 19th day of July, 1866, and their descendants who reside within the limits of the Cherokee Nation shall be taken and deemed to be citizens of the Cherokee Nation.
So sometimes we look at a lot of the 5 civilized tribes and we see white looking people and we just can't understand. Well, here, this particular treaty grants whites living within the Cherokee Nation's citizenship. So when we see them, it doesn't necessarily mean that they are Indians. It means that they were living amongst the Indians at the time the treaty was made.
Quote unquote. The 4 other descendants. The freedmen were Black individuals who were enslaved by 5 formerly enslaved individuals and their lineal descendants as equal tribal citizens. For example, the treaty signed by the Cherokee Nation reads, and I quote, all native-born Cherokee, all Indians and whites legally members of the nation by adoption, and all freemen who have been liberated by voluntary act of their former owners or by law, as well as free colored persons who were in the country at the commencement of the rebellion and are now residents therein, or who may return within 6 months from the 19th day of July, 1866, and their descendants who reside within the limits of the Cherokee Nation shall be taken and deemed to be citizens of the Cherokee Nation, quote unquote. The 4 other tribes all signed similar treaties. Despite the fact that these treaty obligations still exist and are binding on the 5 tribes beginning in the late 1970s and early 1980s, the tribes began to take formal actions to take away the citizenship rights of descendants of freedmen. For instance, in 1983, freedmen were prohibited from voting in Cherokee Nation elections and received letters informing them that their citizenship had been canceled. In 2007, the Cherokee amended their constitution to limit citizenship to only individuals who were, quote, Cherokee by blood, unquote. These actions led to years of litigation that was finally settled in 2017 when a federal district court judge ruled in favor of the freedmen and their right to citizenship. In this ruling, the judge stated, and I quote, in accordance with Article 9 of the 1866 treaty, the Cherokee freedmen have a present right to citizenship in the Cherokee Nation that is coexistent.
Notice this lawsuit, the freedmen, the quote unquote Black looking people, were the only ones that had to sue. The white ones didn't. The people who were kicked out of the tribe were Black looking people, quote unquote African Americans.
With the rights of Native Cherokees, quote unquote. Following the court decision, which the Cherokee Nation accepted as binding, the tribe has taken actions to comply with the decision and ensure that descendants of freedmen are treated as equal citizens. Settled in 2017, when a federal district court judge ruled in favor of the freedmen and their right to citizenship. In this ruling, the judge stated, and I quote, in accordance with Article 9 of the 1866 treaty, the Cherokee freedmen have a present right to citizenship in the Cherokee Nation that is coexistent with the rights of Native Cherokees, quote unquote. Following the court decision, which the Cherokee Nation accepted as binding, the tribe has taken actions to comply with the decision and ensure that descendants of freedmen are treated as equal citizens. Before my committee, Cherokee Nation Principal Chief Chuck Hoskin testified that these actions have made the Cherokee Nation, quote, a better nation for having recognized full and equal citizenship of freedmen descendants. Despite the actions of the Cherokee to right the wrong inflicted on its freedmen, the descendants of freedmen of the other 4 tribes continue to be denied tribal citizenship and other basic rights associated with citizenship, like equal access to federally funded affordable housing. My committee even heard testimony last year that freedmen have even been denied access to life-saving vaccines during the ongoing pandemic. It was this testimony that prompted even the Biden administration to designate all Seminole freedmen as eligible for healthcare services, including the COVID vaccine, through the Indian Health Service. However, this only decision only applies to Seminole freedmen and not freedmen from the other tribes. We know that equal access to housing sits at the heart of many of the racial and economic injustices we continue to see across the country today.
So we hear a lot that the freedmen were able to gain citizenship to their tribe, and she is pointing out that it's only the Cherokee. And there was an executive order that gave the Seminole rights.
Chairwoman of the House Financial Services Committee, I recognize that Native communities face some of the worst housing conditions in the United States. It is also important to recognize that the legacy of land and cultural disenfranchisement has created and maintained these circumstances. That is why I propose providing $2 billion for affordable housing in tribal communities in my Housing is Infrastructure Act, and why I'm moving to reauthorize NAHASDA with language that ensures that descendants of freedmen have equal access to these resources, as the 1866 treaties promised. When Barney Frank, my predecessor, was chairman of the House Financial Services Committee, he recognized the plight of the freedmen and was a strong advocate for their rights. I worked closely with him on legislation to prevent tribes from disenfranchising their descendants. As ranking member and now chairwoman of the committee, I continue that fight for justice for the descendants of freedmen. Currently, there are tribes that are implementing federally funded programs in a way that actively discriminates against descendants of freedmen in direct violation of treaty obligations. Congress has every right to ensure that federal funding implemented in compliance with all relevant obligations. We must stand by the rights promised to freedmen and the treaties that guaranteed those rights over a century ago and hold these tribes accountable. I'd like to say how proud I am of the descendants of Native freedmen, who have never wavered in their fight for human dignity and equal recognition, even when it seemed no one would listen, even with the growing movement for reparations that recognizes the forced and uncompensated labor that built this country and the riches amassed because of it. It seems that the fight of the descendants of freedmen still has never been rightfully acknowledged in direct violation of treaty obligations. Congress has every right to ensure that federal funding implemented in compliance with all relevant obligations. We must stand by the rights promised to freedmen and the treaties that guaranteed those rights over a century ago and hold these tribes accountable. I'd like to say how proud I am of the descendants of Native freedmen, who have never wavered in their fight for human dignity and equal recognition, even when it seemed no one would listen, even with the growing movement for reparations that recognizes the forced and uncompensated labor that built this country and the riches amassed because of it. It seems that the fight of the descendants of freedmen still has never been rightfully acknowledged and affirmed. This pandemic has made clear that the ongoing discrimination of the freedmen descendants can literally mean the difference between life and death for descendants of freedmen who have been denied COVID vaccines. So I urge the distinguished members of this committee, we must honor our word as a nation and uphold, as honorable people, the obligations of these treaties. This is as much more voices, not less, is the key to productive dialogue. It is when we don't expand our table to hear more from those who have been disenfranchised that injustices and systemic inequities are perpetuated. So moving forward, I'm convinced that we can work together to not simply uplift the voices of freedmen, but also to recognize the shared suffering of Native freedmen and Native Americans forced to walk that trail of tears together, and the need to honor the treaties of 1866. I do not believe that the documented history of the descendants of freedmen can be ignored, forgotten, or dismissed any longer. Thank you. And I'm happy to take any questions that you may have.
Thank you very much, Congresswoman Waters. We appreciate your testimony. Members.
I find it really interesting how the Alaska Congresswoman or Senator, how different she took this than Maxine Waters. That is noted, Ms. Maxine.
May submit follow-up questions for the record, and you are excused as we prepare our next panel.
Thank you very much.
Thank you. If the panelists could take their seats as we're introducing them, I'd appreciate it.
So there was no questions for Maxine.
For our second panel, we have the Honorable Bryan Newland, Assistant Secretary for Indian Affairs at the U.S. Department of Interior, the Honorable Chuck Hoskin, Jr., Principal Chief, Cherokee Nation in Oklahoma, the Honorable Lewis J. Johnson, Chief of the Seminole Nation of Oklahoma, the Honorable Michael Burrage, General Counsel, Choctaw Nation, the Honorable Jonodev Chaudhuri, Ambassador, the Muscogee Creek Nation, Mr. Stephen Greethman, Senior Counsel, Chickasaw Nation, and Ms. Marilyn Vann, President, Descendants of Freedmen of the Five Tribes Association in Oklahoma. I want to remind our witnesses that your full written testimony will be made of the part of the official hearing record, and we would really appreciate it if you could keep your remarks to 5 minutes because this is an extraordinarily packed panel. And we will start with Secretary Newland. Please proceed with your testimony.
Thank you, Mr. Chairman. Good afternoon. Thanks to Vice Chair Murkowski and members of the committee. It's great to be here today. My name is Bryan Newland. I have the privilege of serving as Assistant Secretary for Indian Affairs here at the Department of the Interior. I want to thank the committee for the opportunity to present the department's testimony at this important oversight hearing on select provisions of the 1866 Reconstruction Treaties between the United States and the 5 tribes in Oklahoma. Several of these treaty provisions provide certain rights and privileges to some freedmen, who are people who were enslaved and later released from servitude by the Cherokee, Choctaw, Chickasaw, Muscogee Creek, and Seminole nations, called at times the 5 tribes. The department appreciates the opportunity to discuss these important treaty provisions. Each of the 5 tribes enacted laws supporting enslavement and/or restricting the rights of enslaved people. In 1866, after the Civil War, each of the 5 tribes entered into treaties with the United States. Those treaties contain provisions addressing the status and rights of freedmen and persons of African descent residing amongst the 5 tribes. It is important to understand that there is no single treaty or uniform law that applies to all freedmen. The Cherokee Nation, the Muscogee Creek Nation, and the Seminole Nation each have their own treaty with the United States, and the Chickasaw and Choctaw Nations share a treaty in common with the United States. All 4 of these treaties have slightly different provisions relating to the freedmen. In 1896, Congress established a commission to the 5 civilized tribes to prepare membership rolls for each of the tribes in anticipation of allotting their lands. Congress directed the commission to determine applications for citizenship in each of the 5 tribes in accordance with their treaties and their laws. Congress also required the commission to make a roll of freedmen entitled to citizenship in said tribes and to include their names in the lists of members. The final rolls would remain with the Commissioner of Indian Affairs and be considered the true and correct rolls of persons entitled to the rights of citizenship in each tribe. In the past half-century, there have been disputes within some of the 5 tribes regarding the legal status of freedmen descendants. The Cherokee Nation resolved the dispute over the status of Cherokee freedmen utilizing its own judicial and political processes. In May of last year, Secretary Holland approved the Cherokee Nation Constitution that explicitly secures the citizenship and political rights of Cherokee freedmen. In a statement accompanying her approval, Secretary Holland stated that the new Constitution, quote, fulfilled the nation's obligations to the Cherokee freedmen and encouraged other tribes to take similar steps to meet their moral and legal obligations to the freedmen. In February, I participated in consultation sessions with leaders of the 5 tribes to consider the potential for some direct services to the freedmen from the BIA and the BIE. In particular, we asked the tribe's views on whether the Bureau of Indian Education should admit certain freedmen descendants as students at Haskell Indian Nations University and at Southwestern Indian Polytechnic Institute. We continue to review feedback and comments received from that consultation and have not made any decisions on a path forward. Determining eligibility for those services is a challenge for the department when considering the freedmen descendants. The department generally defers to tribes to determine who is and who is not a tribal citizen, as tribes have inherent authority to determine who qualifies as a tribal citizen. And as sovereign parties to treaties, tribes have an important role to play in interpreting those treaties with the United States. However, as Secretary Holland stated last year, the department continues to encourage tribes to take steps to meet their moral and legal obligations to freedmen descendants.
I just want to make a quick point that he spoke with the tribes to allow some of these freedmen that there was already a court hearing about that are citizens and is part of the family, the Indian family, to allow them to go to their colleges, and no decision was made. Just for them to become students.
However, as Secretary Holland stated last year, the department continues to encourage tribes to take steps to meet their moral and legal obligations to freedmen descendants. The department's grateful to have the 5 tribes together here today, along with Ms. Vann, and we look forward to continuing our work with the 5 tribes and with the committee as we consider the legal rights and the status of freedmen descendants. Thank you, Mr. Chairman.
Thank you, Mr. Newland. Chief Hoskin, please proceed with your testimony.
OCO, Mr. Chairman, members of the committee, what for inviting me to speak today. Supreme Court Justice Hugo Black once wrote that great nations like great men should keep their promises. Cherokee Nation is keeping our promise to the Cherokee freedmen and their descendants under our Treaty of 1866. That treaty, Mr. Chairman, is a living, powerful, and foundational document that ties together every one of our agreements with the United States. When we speak of our most important treaty rights, our reservation in Northeast Oklahoma, our right to a delegate in the House of Representatives, for example, we point to the language in the Treaty of 1866, which reaffirms all of our prior treaties, not inconsistent with that treaty. Cherokees must defend and we must preserve the Treaty of 1866. Article 9 of that treaty states that, quote, all freedmen and their descendants shall have all the rights of native Cherokees, not some of the rights, all of the rights. Treaty obligations ought to mean something. Mr. Chairman, you can't pick and choose which parts of a treaty to uphold. We criticize the United States when it fails to live up to its treaty obligations, yet we in Cherokee Nation have a responsibility to live up to ours. For Cherokee Nation, the issue of freedmen citizenship was settled 156 years ago. It was settled in a treaty agreed to by the Cherokee people, ratified by this Senate, and signed by the President of the United States. Our ancestors agreed in 1866 to forever cede the right to exclude freedmen and their descendants. This means that Cherokee Nation's past actions to exclude freedmen descendants from Cherokee Nation were void ab initio, void from the beginning. The enslavement of other human beings and the subsequent denial to them and their descendants of their basic rights is a stain on the Cherokee Nation. And it's a stain that must be lifted. Mr. Chairman, I offer an apology on behalf of the Cherokee Nation for these actions. Just as important, I offer a commitment to reconciliation. I'm proud of the many actions that we've taken over the last 5 years towards reconciliation. In 2017, a federal district judge decided the Nash case. That case confirmed that the 1866 treaty remains alive and well and guarantees that descendants of Cherokee freedmen shall have, quote, all the rights of native Cherokees. To bring that matter to a close, Cherokee Nation did not appeal. The day after that historic decision, our own Supreme Court affirmed full citizenship for freedmen. We immediately began processing applications for citizenship from freedmen descendants. To this day, Mr. Chairman, more than 11,800 applicants have become citizens. In 2021, our Supreme Court unanimously ruled that the by blood language in our Constitution also violated our obligations in the Treaty of 1866. Our High Court determined that those words were invalid from inception and must be removed. As noted, Secretary Holland reviewed our Constitution later that year, and she wrote the Cherokee Nation had, quote, fulfilled their obligations to the Cherokee freedmen. The Nash decision and our swift actions to implement it was a beginning. It was not an end. We understand that we must embrace the spirit of equality each day. For more than a century prior to the Nash case, freedmen had been disconnected from the Cherokee Nation. Many in the freedmen community did not have the same experiences, the same access to services, the same opportunities as non-freedmen citizens. It's essential that we work to bridge that gap. So in 2020, I issued an executive order on equality, reiterating our commitment to that ideal. We also need to make sure that we are mindful of the freedmen experience. So in 2021, I announced the Cherokee Freedmen Art and History Project, which seeks to ensure that freedmen voices are represented within the Cherokee story. I'm proud to appear with my friend Marilyn Vann, who I appointed last year to our Environmental Protection Commission, the first Cherokee citizen of freedmen descent to hold a Cherokee Nation appointed government post. Mr. Chairman, I'm here today because it's a moral imperative that I be here. I'm here to proclaim that having finally kept our promise to Cherokee freedmen, Cherokee Nation is a better nation. It is a stronger nation. Mr. Chairman, I'm here representing a great nation. Whatever.
Thank you very much, Chief Hoskin. Chief Johnson, please proceed with your testimony.
Good afternoon, Chairman and the rest of the committee. The Seminole Nation thanks you for this time to be able to speak. It has been requested of us to expand on selected provisions of the 1866 treaty. The communication to the Seminole Nation stated that in emails. A treaty was written to favor the necessities and the desires of the United States, although it was stated to be mutual necessities. I will now expand from the preamble and certain articles of the 1866 treaty for the Seminoles. Selected provisions from the preamble. Whereas existing treaties between the United States and the Seminole Nation are insufficient to meet their mutual necessities, and in view of the urgent necessities for more lands in the Indian Territory, requires a cession by said Seminole Nation a part of their present reservation, and is willing to pay therefore a reasonable price, while at the same time providing new and adequate land for them. The first phrase of the preamble is the opening words of the 1866 treaty. The existing treaty reference is the 1856 treaty, which was in fact sufficient for the Seminole, for it consisted of millions of acres of land and provided in the language of that specific treaty that the desires of the United States were the determining factor for the Seminole being the only tribal nation of the Reconstruction Treaty era forced to cede every inch of their land. 2,169,080 acres was ceded at 15 cents an acre. The Seminole understood the 2,169,080 acres ceded was to be assigned to other Indians and freedmen to live thereon. This promise was neither fulfilled nor honored. This language is present in Article 3 of the 1866 treaty and is the first time in the treaty where the term freedmen is mentioned. As stated in the preamble, a need for ceded land was for only a part, not the whole of the Seminole original initial reservation. It is a fact a reasonable price was never paid for the ceded land during this era, 15 cents an acre, nor was adequate sufficient land provided as understood by the Seminole. The first sentence of Article 3 reflected the intent of the United States as the Seminole understood it to mean. The 1866 treaty ultimately was not honored in totality by the United States because the intent of Article 3 was not adhered to. There are documents from all three branches of the United States government addressing this specific section of land. That fulfills my time at this time. I'm splitting my time with Assistant Chief Palmer.
Assistant Chief Palmer, please proceed.
Thank you. Mujinita, Haraniram, Nedethuzlan Pum Bahoyan, Momen Pum, Ojoagi, Dadi, Ojobagi, Sabaklet, Mongis. During opening remarks in the Haas reauthorization 1 year ago on this date, the following was stated. The United States signed more than 370 treaties, passed laws, and instituted policies that have come to define the special government-to-government relationship between the federal and tribal governments and obligates the federal government to promote the general well-being of Native American tribes. Yet, the United States has failed to provide that assistance. Any treaty must be viewed through the author's eyes and those who reluctantly agreed to it. Weighted consideration must be given to the government's chosen language, intent, and the atmosphere in which it was constructed 156 years ago. This is how the U.S. Constitution is viewed. This is how the treaties are viewed. Article 2 of the Seminole Nation Treaty of 1866 reads, in part, many persons of African descent and blood who have no interest.
This is the representative of the Seminole Nation. I can't even get this out my mouth. Y'all serious? Come on.
interest or property in the soil, and no recognized civil rights shall be permitted to settle, have and enjoy the rights of all native citizens, equally binding laws, and may be adopted as citizens or members. The Dawes Commission certainly categorized Freedmen and Seminole separately and introduced blood quantum. Phrases and terms utilized within the treaty are not the words of the Seminole. They're the words and desires of the federal government. This short testimony to discuss select provisions is a disservice to the Seminole and warrants a deeper conversation. Grossly negligent oversights of the treaty agreements still occur beyond the McGirt case. The government must account for and consider the impact any decision may have on a financially fragile tribal system that has yet to overcome historical poverty caused by previous lack of protection defined by the treaties in times of war and hostility, loss of valuable oil and land, and continual suffering from the historical trauma caused by the Indian Removal Act. As an elected official under the oath of office of the Seminole Nation, I must uphold the treaty, the tribal and U.S. Constitution, the tribal codes as they are written and as they govern the Seminole. Mado.
Thank you very much. Mr. Burrage, please proceed with your testimony. Am I pronouncing your name correctly?
Burrage.
Burrage.
Yes, Senator. Thank you and good afternoon, Chairman Schatz, Vice Chairman Mikowski, Senator Langford, and Senator Smith, and all other distinguished members of the committee. My name is Michael Burrage. I am General Counsel for and a member of the Choctaw Nation of Oklahoma. I'm here at the request of and on behalf of the Chief of the Choctaw Nation, the Honorable Gary Batten, who the committee invited to testify on a matter of grave importance to the integrity of the Choctaw Nation. I began representing the Choctaw Nation in 1974 upon graduation from the University of Oklahoma College of Law. At that time, I moved to Antlers and began my law practice. I have represented the Choctaw Nation ever since that time in 1974, except for an approximate 7-year period when I was appointed by President Clinton to be a United States District Judge, being Chief Judge for 5 of those years and also serving on the 10th Circuit Court of Appeals by designation. I was told that I am the first Native American to be appointed to the federal bench. I want to make one thing very clear, and please listen. The Freedmen issue, as it relates to the Choctaw Nation, has nothing to do with race. I repeat, has nothing to do with race. Tribal membership is based on blood, not race. Today, the Choctaw Nation tribal members includes African Americans, as well as those from other races. All members of our tribe share one characteristic in common.
That's obvious.
They are Choctaw by blood, and they're all lineal descendants of Choctaw Indians. The Constitution of the Choctaw Nation was established by a United States District Court order dated May 9th, 1983, in an action entitled Morris versus Watt. With federal approval by the government on June 9th, 1983, I repeat, with federal approval by the federal government on June 9th, 1983, ratified by a vote of the tribal members, certified by the Choctaw Election Commission on July 25th, 1983, this Constitution, approved by the federal government, limits membership to Choctaws by blood and their lineal descendants. Chief Batten and I, as General Counsel, take an oath to uphold and defend this Constitution.
Okay.
Our Constitution has existed and worked well for almost. How can this be squared with the United States government's trust duties and obligations to the tribes? How is this anything that undermining the tribal self-determination and tribal autonomy? After surviving the cruelty of the Trail of Tears, the Dawes Act, the near termination of our tribal functions, and nearly 2 centuries of taking at the hand of the United States government, the Choctaw Nation and these other tribes deserve better. This all goes
I thought this was about the Freedmen.
to the core of the constitutional identity of a sovereign tribe that is threatened. Thank you for your attention to this matter. And when appropriate, I'll be glad to answer any questions about what I have said or other such important matters as tribal membership. Then you add on top of that, legislative threats are made. If the tribe does not make the decision wanted by some politician, critical housing funds for tribal members that need the housing may be withheld. How can this be squared with the United States government's trust duties and obligations to the tribes? How is this anything that undermining the tribal self-determination and tribal autonomy? After surviving the cruelty of the Trail of Tears, the Dawes Act, the near termination of our tribal functions, and nearly 2 centuries of taking at the hand of the United States government, the Choctaw Nation and these other tribes deserve better. This all goes to the core of the constitutional identity of a sovereign tribe that is threatened. Thank you for.
Okay. So this man feels like it's threatening. Now, we all seen old pictures of Indians, supposedly Indians. And he feels it's threatening for them to allow the Black brothers and sisters to become part of the tribe.
Thank you for your attention to this matter. And when appropriate, I'll be glad to answer any questions about what I have said or other questions, especially about the Morris case. I was there. I represented the tribe, although at that point in the game, I was carrying briefcases more than lawyering, but I know what was discussed at those hearings, and this was one of them.
Thank you very much. Ambassador Chaudhuri, please proceed with your testimony.
Mado, I've got a long history with these buttons. Do I have it right, sir?
You got it
You're
right.
doing great.
Thank you. XG, Jonodev, Osula, Chaudhuri, Joseph Kudos, Kasagamasi, Ibufunga, Amalga, with Mitus. Mr. Chairman, Vice Chair, members of this esteemed committee, Thank you for the opportunity to testify. My name is Jonodev Chaudhuri, and I'm proud to serve as ambassador of the Muscogee Creek Nation. As I sit here before you today, the sovereignty of all tribal nations is under attack. 2 years ago, the Supreme Court upheld our nation's sovereignty in McGirt versus Oklahoma. Just this past month, however, the court chose to abdicate it in order to placate Oklahoma politicians. Congress has a duty to protect the sovereignty of all tribal nations. That duty is all the more pressing when one branch of the federal government seeks to eliminate it. The Freedmen issues trace their roots to injustices against both Native Americans and African Americans. It goes without saying that slavery is and always has been wrong. And just as the United States fought a civil war over slavery, the Creek Nation fought its own civil war. On one side were the traditionalist Upper Creeks, who opposed the imposition of colonial American life into our nation, including the legalization of slavery. I'm a descendant of Fish Pond and other Upper Creek towns. My mom used to explain family oral history, stating that when our family and other Creeks would raid slave owners, we would give freed slaves 3 options. 1, receive our assistance for passage to the north. 2, live among us and with us. Or 3, join an autonomous Black community within the larger Muscogee world. However, these practices conflicted directly with the goals and desires of the most prominent Lower Creeks, who sought to fully assimilate every aspect of white American culture into the fabric of our nation, including slavery, cotton, and Christianity. Instead of allowing the conflict at Creek Nation to play out through our own internal democratic processes, the United States intervened and dispatched General Andrew Jackson to exterminate the Upper Creeks. The United States' goal was nothing less than complete annihilation. In 8 months of massacres, the United States burned nearly every Upper Creek home and murdered thousands of men, women, and children. My ancestors from Fish Pond sought refuge at Horseshoe Bend on the Tallapoosa River in Alabama, and they were slaughtered by Jackson and the slave-owning Cherokee leaders, John Ross and Major Ridge, who volunteered to fight with them. At Tallahassee, Jackson locked 50 men, women, and children in a cabin and burned them alive. Horseshoe Bend and the scores of massacres that preceded it silenced the strong anti-slavery faction within the Creek Nation. Jackson's extermination policies against the Upper Creeks created Alabama and resulted in the Indian Removal Act and ultimately the Trail of Tears. Even so, thousands of Creeks fought on the side of the Union in the American Civil War. Once again, we were targeted. Our homes burned and hundreds died. In exchange for our loyalty, the United States promised that once the war ended, our nation would not lose any land and all of the loyal Creeks would be financially assisted. Both promises turned out to be lies. The Treaty of 1866 has often been characterized as a Reconstruction Treaty. For us, it was not. It was a land grab that stripped us of half of our reservation by force. And my great-great-grandpa up Knee Hill, who fought for the Union, said the final payment from the United States wasn't enough to buy a hat. It is important to note that we are not Cherokee Nation. We are not Chickasaw Nation. We are the Muscogee Creek Nation. Our treaty with the United States contains different language than the treaties of other tribal nations. Our current Constitution was reviewed and approved by the Department of the Interior. However, the interpretation of this treaty is currently the subject of ongoing litigation. Any true solution must go beyond the shallow political rhetoric and the yes-no binaries that such rhetoric supports. To that end, we've begun a process at Muscogee Creek Nation of developing historical, cultural, and legal research that will help our citizens engage in a thoughtful, informed exploration of this issue as they exercise their sovereign right to determine the future of the Muscogee Creek Nation. The Muscogee Creek Nation is proud of our diverse citizenship. We have citizens who have mixed ancestry, who are also white, African American, Mexican American, and many other heritages. I myself am Creek and Asian. But whatever else we may be, we are all Creek Indians by blood. And as a nation that has endured.
So you think everybody will look at this man and think he looks like an average Native American, but he just told you that he is mixed. The reason why he looks like the quote unquote stereotypical Indian is because he is Indian and Asian. Listen.
Sovereign right to determine the future of the Muscogee Creek Nation. The Muscogee Creek Nation is proud of our diverse citizenship. We have citizens who have mixed ancestry, who are also white, African-American, Mexican-American, and many other heritages. I myself am Creek and Asian. But whatever else we may be, we are all historical, cultural, and legal research that will help our citizens engage in a thoughtful, informed exploration of this issue as they exercise their sovereign right to determine the future of all Creek Indians by blood. And as a nation that has endured policies intended to exterminate us because we are Creek Indians by blood, citizenship and issues involving non-Creek persons engender deep conflicting emotions. Quite frankly, our citizens stand on both sides of these issues. We're working towards healing. We're not only the descendants of select families that owned slaves, but also those who opposed slavery and incurred the targeted and murderous wrath of the United States military. But the solution to this is not another colonial intervention by the United States. Mado.
Thank you very much for your testimony. Mr. Greetham, please proceed with your testimony.
Thank you very much. Chairman Schatz, Vice Chairwoman Murkowski, and honorable members of the committee. My name is Stephen Greetham. I serve as senior counsel to the Chickasaw Nation. I want to thank you for the opportunity to speak today.
It's funny how the white ones ain't going to divulge what they're mixed with.
The committee called this hearing to inquire as to freed person descendants' tribal citizenship rights under various 1866 treaties. For Chickasaw, this inquiry is controlled by Article 3 of our 1866 treaty, a treaty to which the Choctaw Nation is also a party. The United States Supreme Court adjudicated the committee's question more than a century ago. Consistent with that adjudication, we have not violated, nor are we violating our treaty. But before I go further, let me state plainly, human chattel slavery is a stain on history. It is a stain on the continent's history, on the United States' history, and on Chickasaw history. Likewise, Jim Crow is a stain on the United States and Oklahoma's history. There's no room for ambiguity on those points, and nothing I say today should be interpreted as suggesting any ambiguity. Relevant to the committee's inquiry, the Chickasaw Nation's 1866 treaty provides for a land cession to the United States, but conditions federal compensation on the nation's choosing to extend citizenship to freed persons. That choice was neither made nor supplanted by the treaty, which only spoke to the consequence of whichever choice the Chickasaw made. The Chickasaw people deliberated and chose not to extend citizenship. In doing so, the Chickasaw expressly relinquished any claim to compensation for the lands the United States took. This choice was not a violation of the treaty, but its implementation. And of course, as the Supreme Court recently quipped, history did not stop in 1866. In the wake of restored treaty relations, the U.S. again broke faith. Giving in to non-native political pressure, Congress turned its efforts to undermining tribal self-government and opening indigenous lands to non-native settlement, so Oklahoma could be formed as a brand new state. It should be remembered that throughout this period, Chickasaws themselves were not U.S. citizens, though they and their rights remained subject to Congress's claim to plenary authority over Indian affairs. In the chaos resulting from this pressure campaign, disputes over freed person rights arose. And in 1902, Congress directed us to court. And by us, I mean the United States and the Chickasaw Nation and the Freedmen and the Choctaw Nation. Here's Congress's language. Authority is hereby conferred on the Court of Claims to determine the existing controversy respecting the relations of the Chickasaw freedmen to the Chickasaw Nation and the rights of such freedmen in the lands of the Choctaw and Chickasaw Nations under the third article of the Treaty of 1866 between the United States and the Choctaw and Chickasaw Nations and under any and all laws subsequently enacted by the Chickasaw legislature or by Congress. In considering the case, the court concluded, 1, Congress had not independently vested freed persons with citizenship, and 2, the treaty did not impose an obligation for the tribe to do so. Instead, the treaty provided for potential citizenship. As the Court of Claims put it, quote, a means whereby freedmen might, by consent of the tribe and the voluntary action of former slaves, become members, close quote. Based on treaty text and the parties' actions, the court ruled freed persons were, quote, relation to the Chickasaw Nation is, as the treaty expresses, the same as citizens of the United States in the nation. This remains a true statement of law and fact today. And again, the statement represents treaty implementation, not violation. Treaties matter. They're the supreme law of the land. The federal legal system both produced the Chickasaw Nation's 1866 treaty and adjudicated its meaning more than a century ago. We are both, the Chickasaw Nation and the United States, bound by the court's disposition of the matter. Mindful of questions the law does not answer, though, Chickasaw stands by this process and result. All peoples work to reconcile their often complicated histories over time. The U.S. and Chickasaw signed the 1866 treaty during a difficult period in our shared history, a period in which the United States began its own process of reconciling its dehumanizing reliance on human chattel slavery. We're more than 150 years on now, and that process continues, as it should. But the law matters. Chickasaw history, like other histories, involves growth and setback, trial and progress. In its most recent generations, the nation has made tremendous progress in rebuilding its governing institutions. Today, it employs thousands, both Chickasaw citizens and, like me, non-citizens. It invests in communities throughout its reservation, Oklahoma, and the region. It is dynamic and its work is ongoing. It remains committed to this rebuilding effort and engages in it consistent with the law and its people's right to sovereign self-determination. Thank you for the opportunity to speak to you today, and thank you for the opportunity to start conversation.
Thank you very much. Ms. Vann, please proceed with your testimony.
That man didn't say anything about being a mixed heritage.
And distinguished members of the committee, thank you for giving me this opportunity to be a hearing witness. I am Marilyn Vann, president of the Descendants of Freedmen of the Five Tribes Association. I'm a Cherokee citizen and a Freedmen descendant. We support enforcement of 1866 treaty rights of Freedmen descendants. The tribes allied with the Confederate States to protect Black chattel slavery. The 1866 treaties granted the Creek, Cherokee, and Seminole in 1885. Chickasaw freedmen were not members of the tribe at the time of the Dawes enrollment as per the federal courts. Many descendants today need services the same as their by-blood relatives. Poverty began of the freedmen during slavery. Later, freedmen suffered from race massacres, segregation, and redlining. Freedmen descendants disenrollment began in 1979. The freedmen, members of the tribes that were disenrolled, were not allowed to vote on the disenrollments or only in nominal numbers. Currently, only Cherokee Nation works to fulfill its treaty obligations to freedmen. As a result of past and current systemic racism, descendants need help of the senators. Some that need help include Creek Freedman descendant, Mr. Lovett of Okmulgee, a senior citizen on disability. He needs rental assistance. Can the tribes change without congressional and federal intervention? History says no. Cherokee Nation only came into compliance in 2017 after federal court decisions in Cherokee Nation v. Nash and Vann and passage of Freedmen protective language in the 2008
Family. We supposed to believe this lady is an African slave? Come on. And I get that we all have to start somewhere, and they were able to open the door. But this lady knows she's an Indian. And she's sitting up here, I applaud her. I think that she is working. But don't be like the ancestors that sold out the rest of the family.
HASTA Reauthorization Act. Even today, some council persons and candidates for tribal office run anti-freedmen rights campaigns. The Seminole Nation has worked to exclude freedmen descendants from receiving almost all services, even after losing the Seminole Nation v. Norton case, federal case in 2002, and receiving directions from the DOI and HUD that the freedmen citizens qualify for services. Their leadership has branded the freedmen as citizens rather than members, which legally means the same, and reissued freedmen tribal IDs that state 0 blood quantum and voting benefits only. The Seminole tribal government has told other tribal nations and federal agencies the freedmen citizens do not qualify for services. In October 2021, Seminole freedmen began receiving medical services after the IHS sends orders to all chiefs and tribally operated health units
that the freedmen citizens qualify for the health services. This came after my visits to the Rockville IHS headquarters with Seminole Councilwoman Sampson, who is here today, requesting urgent help. The freedmen elders dying from COVID-19, such as Mr. Thomas, whose wife was on the council, was covered by the national press when tribal and IHS COVID vaccines were denied to Seminole freedmen, tribal citizens, but given to other members of the tribe. The Muscogee Creek Nation stresses the validity of Article 3 of its 1866 treaty, which confirmed the reservation, Seamagurt v. Oklahoma, but is silent on Article 2 of the same treaty that granted the enslaved people and their descendants the right to share in the national funds and all the rights of Indians. Article 2. Greek freedmen descendants went to tribal court, but have been waiting for a judge to be assigned to the case since February 2021. The Creek Nation issued $4,500 checks from COVID-19 funds to each by blood citizens. Not a nickel went to the Creek freedmen, a clear violation of that treaty. By the way, the Seminole Nation leadership denied the freedmen citizens its share of the COVID funds as well. This committee can assist the freedmen. Here are some suggestions. We ask Congress to write legislation that includes freedmen descendants in appropriations, new programs, or reauthorization of old programs or entitlements that benefit the nations. This must be done by congressional language. The DOI can register freedmen descendants, giving those that provide proof of descendancy of a Dawes enrollee a letter confirming the person is a treaty heir who qualifies for federal services. We request field hearings or local listening sessions to be held in Oklahoma by members and staff of the Senate Committee on Indian Affairs, so more voices can be heard. We ask for investigations and CRS reports on the Freedmen Treaty issues. These do not equate citizenship, but would be a start. Thank you, Chairman.
Thank all of our testifiers. Really extraordinary testimony. All of you deeply professional, deeply knowledgeable, obviously not in agreement. Some intense frustration expressed. I respect that. These issues, as I said before, are foundational to people's identity, to communities, to tribal identity. And so I just wanted to acknowledge the professionalism with which you all delivered your testimony. I'll start with Mr. Newland. I understand the department is currently gathering data related to freedmen eligibility for certain federal benefits. Can you just talk a little bit more about what's going on in that process and how it's coming along?
Thanks, Mr. Chairman. So as I mentioned in my testimony, we had conducted consultation, formal government-to-government consultation with the 5 tribes back in February. We received, in addition to sitting down and having a conversation on some of these same issues, we received comments. And the question was whether to admit non-tribal member freedmen descendants as students at Haskell and SIPI. One of the challenges with that is that the BI is not currently set up in a way where we have the capacity to make determinations about who would and would not be eligible. We typically rely upon tribal governments for membership and citizenship questions. And so we haven't yet decided on definitively on a course of action coming out of that consultation, but those are some of the issues that we were considering.
So I'm sort of assuming you can't answer this question, but based on the data that you're gathering so far, do we have a ballpark number of how many freedmen descendants have equities across the 5 tribes?
I don't have that number, Mr. Chairman.
Thank you. There's been talk, Ms. Vann's testimony talked about a CRS report. There's been talk among staffers about a GAO report, and just cards on the table as I'm thinking about the path forward. That strikes me as an important first step. just to sort of set a baseline of how each of the 5 tribes are in a different situation, both in terms of their treaty obligations, but also their current view of the issue and where they may or may not be in pending litigation. But also some baseline data about how many people are we talking about, right? What percentage of the current roles would this constitute? What kind of resource requirements would that implicate? And so I'm wondering what your thoughts are about a GAO report to try to get a level set here about the history, the legal aspects, the mechanics of conducting a role. I know something about this from the Native Hawaiian community. You know, the blood quantum questions, the lineal descendancy, they're not so easy to settle. And so even before you get to the potential for public policy in this space, you need to know what the facts are. And so I'm wondering what you think about that.
Mr. Chairman, we would be happy to work with the committee to and better understand kind of how that study would be set up. But you hit the nail on the head that simple descendancy does not, in and of itself, doesn't necessarily mean that somebody would be an eligible freedman descendant, because each tribe has a slightly different citizenship requirements. And so, the short answer to your question is we'd be happy to continue those conversations to look at how we would better define the universe here.
My final question before I turn it over to Vice Chair Murkowski, and I'll do a second round to try to ask some additional questions. Chief Hoskin, you testified that the nation has approved and processed just under 12,000 citizenship requests. Do you have an idea of, was it an initial rush and now you just have a few coming in the sort of regular order, or are there a lot of requests still pending for processing? How is this working?
There was an initial rush because of the obvious news of the court decision and how we embraced it. But the number has grown steadily. So when I testified before a House committee earlier this year, we were somewhere in the neighborhood of the 8,000 range. And so that gives you an idea. Now we're closing in on 12,000. Now we are the largest tribe by population in the United States, coming on to 440,000 citizens in that neighborhood. I think as we go out and engage in our outreach, Mr. Chairman, we are encouraging more people to sign up. And it's a rigorous process, and it should be, but we are doing outreach, and I think that's why you see our numbers continue to grow. I don't know what the ceiling is, and I don't know right now whether we can get the committee this information, what our pending applications are, but we process thousands of applications for citizenship every month for potential Cherokee citizens of all sorts of descent, including Cherokee by blood and Freedmen. So I think that number is just going to continue to grow.
And just before I turn it over to Vice Chair Murkowski, just for the other representatives of the tribes, whether over the table or in subsequent correspondence, I am going to try to get some fidelity on how many people we're talking about for each of your tribes and what percentage of your current membership that may comprise. I understand that is sometimes sensitive information, given that you are sovereigns, and so I want to be respectful of that. But I also think for decision-making purposes, we need to sort of understand not just the legal and moral and historical implications, but how many people are we talking about, and if it is a resource question, what it would cost to address. So just to let you know, those questions are coming, and I'm sensitive to the idea that maybe you don't want to give me incredible precision with a microphone on. Vice Chair Murkowski.
Thank you, Mr. Chairman. And I'd like to begin with a question to you, Assistant Secretary Newland. When Secretary Holland approved the Cherokee Nation's new constitution guaranteeing full citizenship, she did state very clearly, tribal self-governance is the best path forward to resolving internal tribal conflicts. We encourage other tribes to take similar steps. But as we have heard very clearly today, the treaties that the 5 tribes are under are very different, and therefore the obligations to the freedmen and their descendants are at question here, of course. So the question to you is, if the tribes treaty does not require it to extend membership to freedmen, what federal obligations does the federal government have to the freedmen and to their descendants? And I guess a follow-on to that would be if there are any administrative authorities that the Department of Interior possesses that could be utilized to address the concerns. You indicated that consultation has been underway and discussions about BIE and BIA, and the department has not determined yet how to move forward. But can you speak again to the federal obligation and also to potential administrative authorities?
Thank you, Madam Vice Chair. I want to make sure I'm understanding your question correctly. Are you asking if a freedman descendant does not have a legal right to tribal citizenship, at that point, what would the United States obligation
Correct.
be?
What would the obligation be then to the freedmen and to their descendants?
Yeah. Thank you, Madam Vice Chair. If there's no legal right to tribal citizenship, it's not clear then that the United States would have a trust duty to any individual as though they were Indian or as though they were a tribal citizen.
And so what about any administrative authorities within the department to address some of the concerns that we've heard articulated today?
Thank you, Vice Chair. This has been a difficult question for us to answer. I know some folks here in the room have views that these questions are clear, the answers are clear on their face, but in terms of how we would administer direct services to freedmen descendants, again, it's very difficult for us to put that into practice through the BIA because we're simply not set up or not constituted right now to make determinations about who would be a lawful or legitimate freedman descendant entitled to those services and who would not be. And so I guess the answer to your question is it's just not clear today what administrative capabilities we would have.
So let me ask yet probably another hard question, and that is a recognition that as sovereign parties to treaties, tribes clearly have an important role in interpreting the meaning of the treaties, but the United States is also the other sovereign party to the 1866 treaties that are signed by the 5 tribes. So the question would be, what role does the United States have to interpret and enforce the terms of these treaties as the other signatory? Probably not easy again for you to respond to.
Thank you, Vice Chair. They're all hard questions, which is why I think we're here in this setting today. Both sovereigns that are party to a treaty have a responsibility to fulfill the terms of the treaty and also have a right to help determine the treaty in its meaning. I think that the Cherokee Nation's journey here is a great example of the mix of diplomacy between the United States and the Cherokee Nation, but also the Cherokee Nation exercising its inherent sovereign powers through
clearly have an important role in interpreting the meaning of the treaties, but the United States is also the other sovereign party to the 1866 treaties that are signed by the 5 tribes. So the question would be, what role does the United States have to interpret and enforce the terms of these treaties as the other signatory? Probably not easy again for you to respond to.
Thank you, Vice Chair. They're all hard questions, which is why I think we're here in this setting today. Both sovereigns that are party to a treaty have a responsibility to fulfill the terms of the treaty and also have a right to help determine the treaty in its meaning. I think that the Cherokee Nation's journey here is a great example of the mix of diplomacy between the United States and the Cherokee Nation, but also the Cherokee Nation exercising its inherent sovereign powers through its own political processes and its own judicial process to resolve these questions without conflict or having an outcome imposed upon them from outside the nation. And so I think the United States has that ability as well as a sovereign party to the treaty, but that can be, I think the best way to resolve those is within the tribe and through the nation-to-nation relationship.
Assistant Secretary, hopefully this is very quick and very easy, but the Seminole Nation claims
treaty in its meaning. I think that the Cherokee Nation's journey here is a great example of the mix of diplomacy between the United States and the Cherokee Nation, but also the Cherokee Nation exercising its inherent sovereign powers through its own political processes and its own judicial process to resolve these questions without conflict or having an outcome imposed upon them from outside the nation. And so I think the United States has that ability as well as a sovereign party to the treaty, but that can be, I think, the best way to resolve those is within the tribe and through the nation-to-nation relationship.
Assistant Secretary, hopefully this is very quick and very easy, but the Seminole Nation claims in their testimony that there's still some federal services that require the CDIB cards, the Certificate Degrees of Indian Blood cards. These are including services that are provided by both BIA and Indian Health Services. Can you just share with me whether or not a CDIB card is a federal requirement for eligibility to access BIA programs and services?
Madam Vice Chair, typically we refer to a person's status as a tribal citizen or tribal member for the delivery of those services. And in most cases, and I believe with respect to all 5 of the tribes represented today, they perform the CDIB functions under contract with the BIA under their tribal government authority.
Thank you, Mr. Chairman. I'm well over my time. Thank you.
Thank you. Senator Lujan.
Thanks, Mr. Chairman. And thank you to you, Chairman Schatz, and to Vice Chair Murkowski for this important hearing to discuss these respective treaties of 1866. I want to thank each of our esteemed witnesses for taking time to be with us today, and for all of our constituents who are here as well to participate in person, and for everyone that is participating virtually as well with this important conversation. My first question is for Chief Hoskin. How has recognizing Cherokee freedmen as Cherokee citizens affected the Cherokee Nation?
No, I think it's affected us in a positive way. I mean, Mr. Chairman, or Senator, there's something about living up to what we see at Cherokee Nation insofar as our 1866 treaty is an obligation. And we think treaties are solemn promises. So that in and of itself, I think, does something for the Cherokee people. I also think that exploring a part of our history that we have frankly suppressed collectively, individually, and are now doing the opposite, embracing it, is good. Frankly, it's good for the United States to take some scrutiny of its own history. I can say that as a chief of the Cherokee Nation, because the United States has suppressed Cherokee history collectively, individually. We have to look in the mirror, and we have to recognize that we've done the same. Embracing freedmen history going into community, so far as our 1866 treaty is an obligation. And we think treaties are solemn promises. So that in and of itself, I think, does something for the Cherokee people. I also think that exploring a part of our history that we have frankly suppressed collectively, individually, and are now doing the opposite, embracing it, is good. Frankly, it's good for the United States to take some scrutiny of its own history. I can say that as a chief of the Cherokee Nation, because the United States has suppressed Cherokee history collectively, individually. We have to look in the mirror, and we have to recognize that we've done the same. Embracing freedmen history going into communities where many freedmen descendants live, for me as chief, I think it's made me a better chief. It is exposed me to some of the needs in that community that we need to work to meet. And so I just think it's been completely positive. I am not going to suggest that there hasn't been some difficulties in terms of our internal, debates and discussions about whether this is what the treaty meant. I mean, Cherokees are certainly noted for disagreeing from time to time. We have a great and vibrant democracy in the Cherokee Nation, and people have raised their voices. I think that's also been healthy. But ultimately, we respect the rule of law. We respect our ancestors, and our ancestors agreed 156 years ago that freedmen and their descendants should be considered people that have all the rights of native Cherokees. Being able to say that is important. Lastly, Senator, when I come into this chamber or in any forum in which I am pressing the government of the United States to live up to its obligation, I do so as a chief of a nation that's living up to the obligations in that same document. It would be difficult for me, Senator, to come to this committee and press for treaty rights if I could not say to myself, we are living up to all of our obligations. That makes Cherokee Nation, insofar as our treaty is concerned, I think a nation in a stronger position than we would be had we not done that.
Thank you, Chief Hoskin. Assistant Secretary Newland, you mentioned in your testimony that Interior is continuing to review consultation feedback before it makes a decision on whether freedmen are entitled to enroll at Haskell Indian Nations University in Kansas and the Southwestern Indian Polytechnic Institute in New Mexico. Assistant Secretary Newland, although enrollment at BIA post-secondary schools is still under review, what are some direct federal services that freedmen with tribal membership are entitled to?
Thank you, Senator Lujan, for the question. So if freedmen descendants are enrolled as tribal citizens, then they are brought within the scope of our relationship between the United States and tribal nations, and would then be eligible for the services that the federal government provides to that tribe and its members.
Thank you for that. Ms. Vann, yes or no, are Cherokee tribal members with freedman status able to receive every direct federal service and right that the federal government provides to tribal members without freedman status?
No.
My follow-up is, what federal services and benefits are they not eligible to receive despite having full tribal citizenship?
When the Stigler Act amendments were made in 2008, the Act of 1947, the language did not allow freedmen tribal members / freedmen citizens to inherit restricted land from their relatives or spouses of their tribes, and the land would retain its restrictions. One other thing is that freedmen tribal members and freedmen citizens are being treated differently when it on the reservations when it comes to criminal cases. And again, I'm talking about the McGirt decision. So those are the two areas.
I appreciate that response, Ms. Vann. And Mr. Chairman, my time has expired. I do have other questions I will be submitting into the record and to follow up with those that I've asked. Thank you for the time today.
Thank you, Senator Lujan. Senator Langford.
Mr. Chairman, thank you. Thank you to all of you that are here. It's nice to see so many Oklahomans here and get a chance to hang out with neighbors. And very much appreciate your testimony and for everyone coming today. Especially want to be able to thank Principal Chief Hoskins, Chief Johnson, for coming here and to be able to represent and leadership. All of you have done a great job representing your tribe. And I especially want to recognize the two chiefs that are here as well. Also for Marilyn Vann, we met, I'm trying to think, 11 years ago when you chased me down in a town hall meeting at a public library and cornered me in the room to talk about freedmen issues. And we're tenacious about that and has never stopped in the process. So you represent the freedmen well. You have stayed very knowledgeable on these issues and have stayed tenacious in the process on that. So it's great over a now decade-long friendship with us that we have stayed in contact since then. You didn't scare me off when you cornered me in the room to be able to talk through issues, and you still don't scare me off. And so glad to be able to call you a friend as well. Let me just ask a general question on this and to just bring this out because the chairman's trying to be able to figure out how do we get to resolution so this is not another century from now and this same kind of hearing is still occurring. Because many of you referenced these are resolved issues within our tribe. It's been resolved in law. It's been resolved through different treaties. It's been resolved through different arrangements, but it's clearly unresolved in some of these issues. So the key becomes how do we actually get to resolution of this? So can you describe to me the relationship and the number of freedmen that are connected to the tribe that we know of, as you mentioned before, Chief Hoskin's about 12,000 at this point for the Cherokee Nation. The number, and then also what is the current relationship there, whether it is voting rights, whether it is other benefits, or whether it's nothing at all. And that would be helpful just to be able to get some context for the record on that. Chief Hoskins, obviously yours is the easiest to this one, but.
Yes, thank you, Senator. It is good to be here and to spend some time with you. At Cherokee Nation, citizenship is equal. I suspect my good friend Marilyn Vann has the same thing with her that I have with me, which is a Cherokee citizenship card, which apart from our picture and name is indistinguishable. That's where it starts in terms of the symbolic representation of citizenship. But beyond that, there are equal rights. There are no distinctions between Cherokee citizens of freedmen descent or Cherokees by blood descent. I would note for the committee that Cherokee Nation is even more diverse than that. There are Cherokee citizens of Shawnee descent, Cherokee citizens of Delaware descent. Those all stem, Senator, from that same time period, the period of post-Civil War. There is no distinction. I do want to note, if I could take the opportunity, my friend Marilyn Vann noted those two areas in which Cherokee citizens of freedmen descent do not have equal access. Those are two distinctly federal issues for which the Cherokee Nation would support any discussion, any dialogue on how to repair those. Those are not within the control of the Cherokee Nation. So to the extent, Senator, that is within our control, equal rights is the order of the day at the Cherokee Nation.
Chief Johnson, it's good to see you.
Good to see you.
So do you have an accounting of what that number might look like?
Cherokee citizens of Shawnee descent, Cherokee citizens of Delaware descent. Those all stem, Senator, from that same time period, the period of post-Civil War. There is no distinction. I do want to note, if I could take the opportunity, my friend Marilyn Vann noted those two areas in which Cherokee citizens of freedmen descent do not have equal access. Those are two distinctly federal issues for which the Cherokee Nation would support any discussion, any dialogue on how to repair those. Those are not within the control of the Cherokee Nation. So to the extent, Senator, that is within our control, equal rights is the order of the day at the Cherokee Nation.
Chief Johnson, it's good to see you.
Good to see you.
So do you have an accounting of what that number might look like for freedmen that are attached to the Seminole Nation or in relationship there, and what that relationship is like?
The freedmen are numbered within the Seminole Nation citizenship, about 2,500.
Okay.
And I want to say some things on some things that's just what I call innuendos and things. If anyone here has studied the history of the Southeastern tribes, what you're going to find is that the Seminoles are totally separate in the areas of the relationships with people of African, persons of African descent. My land's longest wars in American Indian history was fought between the United States, the Seminoles, and what they were called the Maroons. Some of them were escaped slaves, some of them were free people. That was freedom fighters that were fighting for the same cause, and that was to remain free. The Seminoles have always had the freedmen as their citizens since 1866. We had a Florida lands claims not too long ago, back in the 1990s. That was as a Seminole Nation was recognized by Congress in 1823. The freedmen was not, the so-called freemen at that time was not actually freemen. They were persons of African descent, Maroons, free slave, or escaped slaves from the South. So they were not eligible for those judgment funds as deemed by Congress. Now, what we know as Seminoles is that since 1866, the freedmen have been citizens. They got 2 seats on the tribal council, which is 4 seats on the tribal council. They can vote on measures that's passed by the tribal council of the Seminole Nation. If they come in for enrollment, they come in and they are enrolled as citizens. You know, customs among American Indians are very important. Now, I hear all kinds of words being said this day, but my lands, our treaty says that the terms of the 1866 treaty made it clear that said legislation shall not in any manner interfere with or annul the present tribal organization, the rights, the laws, the privilege, and the customs. It has always been the custom of the Seminole because the treaty says so. It says right here in the treaty that, that its members are citizens. We had that choice to say members or citizens. So I see interchangeably that term being used, citizen, members, citizenship, membership, all that type of thing. And that might work for federal government, but in the customs of the Seminole Nation of Oklahoma, freedmen and the descendants of the freedmen, there's no such thing as a freedman today. I think you know that. They're descendants of freedmen. And they have always been, by custom of the Seminoles, the Seminole Indians have been members of what? Of the native bands, the 12 different native bands within the nation. And once after 1866 and the development of the freedmen bands, they have been members of those particular bands as well. But they have always been seen as citizens. And the customs of the Seminoles that became the specific tribes in Florida that became known as Seminoles, we have always been known as the members of those specific bands, and that's in the Seminole Nation. So that's how the Seminole Nation sees it. That's our oral history. That's our tradition. And I believe the treaty actually supports those two terms being used. And that's how the Seminoles use them in this present day as well.
Thank you, Chief Johnson. Michael Burrage.
Yeah, thank you, Senator. With regard to a path forward, well, before that, I don't have a number to give you. Maybe we can get that, but I don't have a number to give you. But with regard to a path forward,
it's not so much a path forward as it is just a description of the current relationship as far as services. What may be different on that?
The Choctaw Nation does not recognize the freedmen, and that is because of the Constitution. But just one brief word on that Constitution that arose in federal court. The Department of Justice and the Department of Interior were in that case. There was specific discussion about how certain people would be treated, the adopted, the intermarried white, and the freedmen. Right. And a determination was made that it wanted to be Choctaw by blood. Delton Cox from Poto, Oklahoma was on that commission. And I've talked to him, and he said this specific issue was discussed, and the federal government never raised an objection. They never raised the treaty issue. They never raised the freedmen issue and approved this Constitution. We think that Choctaw Nation as a sovereign entity should be able to determine its memberships as set forth by the Supreme Court.
Okay. Thank you, Mr. Burrage. Thank you. Jonodev, I'm going to call you by your first name because we already know each other. So yeah.
Yes, sir.
So give us the approximate number that's in a relationship, if it's known, and then any other benefits or details or connection.
I don't think specific numbers are known because the data is notoriously challenging to confirm the validity of. And along those lines, Creek Nation has been engaged in an active effort to compile data internally and collect historic, cultural, legal information to help provide background for citizens of Creek Nation to have an informed dialogue that's driven by facts, not by political rhetoric. And that informed dialogue, incidentally, may go beyond any specific treaty provision. I want to point this out because the treaty issue is, it's been framed in very conclusory terms about what it says and what it doesn't say. But as I've said before, the treaty itself is working its way through our court system. But beyond that, this information gathering that our chief, Principal Chief Hill, has promoted as part of a national conversation will help inform conversations beyond simple treaty interpretation. Any nation worth its salt has to, including the United States, has to regularly determine whether or not existing laws are consistent with the will of the people. And you need information, you need data to have that discussion. But I would just say, in a previous position, I was at an agency that cited regularly a statutory provision that is often cited in many watershed legislation in terms of Indian affairs. And that legislation talks about the fundamental policy goal of the federal government is to support strong tribal governments. So whether it's through the judicial process of Muscogee Creek Nation or the public voting process of Muscogee Creek Nation, the federal government has a responsibility to support the sovereignty of the nation as it engages in this dialogue. It's important that it does so because, as I said before, colonialist history does not bode well in terms of efforts by the United States to impose its values on these sovereign nations. And we need to learn from history. So one way to turn sympathetic folks in this issue against a federal action is to impose solutions rather than have a true healing process within the nation that's fostered by information. And that's what we're engaged in right now in Muscogee Creek Nation. People may have concerns about timeframes, people may have concerns about when things are going to happen, but any progress of any nation comes in its own time. Yes, we need to push for a conversation, but it can't be imposed by the United States. So thank you, Senator. Your question about data is very well taken. The data, there are historic problems with the data, but we're internally looking at it. I caution against conclusory positions regarding what one treaty position means or a provision means without having the courts take a look.
I get that. Respect that. That's the area that the chairman's been working on for a while and trying to be able to think through how to be able to gather more data. The work that the Muscogee Creek Nation's already done will be very helpful in that process to be able to be informative for a process like that. So that's a helpful piece to be able to have. So I appreciate that very much. And what I think you hear from this committee and certainly from the chairman is how do we work together in this process? I don't hear a federal action to be able to try to step on any kind of tribe in that. It's getting a chance to be able to partner together for things. Mr. Greethman.
It's just a defined terms. The Chickasaw Nation doesn't track freedmen or non-freedmen. There's Chickasaw citizens and non-citizens. As I said, this was litigated over a century ago, so there aren't separate tracks of citizenship. There are just citizens. Many Chickasaw citizens are also folks who are descended from people who were held in bondage. So they could be classified as freed persons, but they're also on the Chickasaw by blood roll, so they count as citizens. I have no number for you as far as folks who are not on the Dawes Commission Chickasaw by blood roll, but are exclusively on freedom roll. I have no number for you.
Okay. All right, that's all very good. Mr. Chairman, I'm ask one follow-up question on. So I apologize for going long. I'm taking my Oklahoma time with Oklahoma folks here in the process, but that's helpful. Thanks for just putting the context of that.
Hold up. It really looks like this lady is sitting behind these people.
You, as far as folks who are not on the.
Is she literally sit behind these guys like a slave?
Dawes Commission Chickasaw by blood roll, but are exclusively on freedom roll. I have no number for you.
Okay. All right, that's all very good. Mr. Chairman, I'm ask one follow-up question on. So I apologize for going long. I'm taking my Oklahoma time with Oklahoma folks here in the process, but that's helpful. Thanks for just putting the context of that on the record because that's helpful to be able to get the context on all those issues. Mr. Newland, I do want to ask a slightly separate question on this just as a follow-up on it. There were two major Supreme Court decisions that have a very direct and immediate impact on Oklahoma. You know them very well as McGirt and the Castro Huerta decisions on that. I need to ask you a question. If the Department of Interior or if you or anyone you know of is currently working on a legislative response for McGirt or for Castro Huerta, is there any ongoing work either from technical assistance or writing? Because this has direct impact on every person that's here and on my state and the 4 million Oklahomans that I represent. So is there any action that's currently going on that you or anyone on your team working on to develop a legislative response to Castro Huerta or to McGirt?
Thank you, Senator. The executive branch has been asked to provide technical assistance on legislative language in response to the Supreme Court's recent decision.
Okay, was that only on Castro Huerta or was it McGirt as well?
Yes, Senator Castro Huerta.
Would you be willing to be able to share that in my office as the senator for Oklahoma? Obviously, that has the direct impact on my state as well and all these folks that are here.
Pardon? Can you?
Would you be willing to be able to share that information with me? Because obviously, as the senator for Oklahoma, that has direct impact on my state.
I don't see a reason why, no reason comes to mind why we wouldn't be able to share that, Senator.
Be great. Thank you. Mr. Chairman, thank you.
Thank you. Senator Langford, just on the question of TA, I don't know who the TA is being provided to actually, but I just want to make sure that they have if it's a member or a member office or a committee office, I want to make sure that they have the ability to work confidentially with counsel and the executive branch. And but I can assure you that the conversations we've had privately about understanding Oklahoma equities are well taken, but I just want to protect Secretary Newland's ability to work confidentially with whatever member or member office may be asking for TA.
Sure.
In fact, it could be my staff. I don't know yet.
I respect that. My biggest challenge is I don't ever want something being worked on or developed as a piece of legislation that has direct and immediate impact on Oklahoma tribes and on the state of Oklahoma, and Oklahoma not actually be involved in that.
Nothing about me without me. I got it. Thank you very much. I just have one final question for Ms. Vann, and I've lost it. Understanding that Oklahoma equities are well taken, but I just want to protect Secretary Newland's ability to work confidentially with whatever member or member office may be asking for TA.
Sure.
In fact, it could be my staff. I don't know yet.
I respect that. My biggest challenge is I don't ever want something being worked on or developed as a piece of legislation that has direct and immediate impact on Oklahoma tribes and on the state of Oklahoma, and Oklahoma not actually be involved in that.
Nothing about me without me. I got it. Conversations we've had privately about
or developed as a piece of legislation that has direct and immediate impact on Oklahoma tribes and on the state of Oklahoma, and Oklahoma not actually be involved in that.
Nothing about me without me. I got it. Thank you very much. I just have one final. In fact, it could be my staff. I don't know yet. Final. Thank you very much. I just have one thing about me without me. I got it.
Oklahoma, and Oklahoma not actually be involved in that.
Nothing about me without me. I got it. Thank you very much. I just have one final question for Ms. Vann, and I've lost it. Oh, got it. Knowing that Congress's authority related to tribal membership is limited by federal Indian law and the language of the treaties at issue today, what do you think can be done to further the cause of reconciliation? I think that although it got a little hot today, and I have no doubt that some people will leave this hearing, maybe even most people will leave this hearing feeling unsatisfied, not vindicated. I consider this a success because we aired it out, and people were heard. And I think it is important to move forward, but I think it is important to move forward carefully. Measure twice, cut once. We want to make sure that we move forward legislatively together. We want to make sure that sovereignty is respected, but we also want to understand that African American enslaved people and Native Americans were mistreated. And we are all in this situation because of the actions of the federal government of the United States. The official policy of the federal government of the United States ends up pitting African Americans and Native Americans against each other in this terribly unfortunate historic circumstance. And so I don't have an easy solution. I think a GAO report is a reasonable start. I think dialogue is an important start, but I'm open to whatever suggestions you may have about moving forward as quickly as we can, but understanding that if we try to move too quickly, it will actually backfire and we will lose another decade of potential progress. So I'm interested in your thoughts, Ms. Vann.
Thank you, Mr. Chairman. I am, as a member of a tribe, I am, certainly I believe in tribal sovereignty, but the United States, of course, does have a responsibility to the Freedmen people as per the treaty, not just to the tribal chiefs and chairmen. Now, decisions have been made regarding the status of the freedmen by some tribal nations, and this comes in part after, Jim Crow laws, which put persons of African ancestry on the bottom of the deck here in Oklahoma. So far as solutions moving forward, where there are some the freedmen have tried to do various things to try to get equity under the treaty. As I said, for instance, there are some Creek Freedmen descendants who have been trying to use the federal courts and also the tribal courts, as well as, of course, coming up here to DC. We would like for the true history of the tribes and the freedmen to be there. So as I said, that's one reason we're calling for studies, because there have been some tribal leaders in the past who have said things like the freedmen were forced on the tribes or snuck in from Arkansas, although there are federal records that say otherwise. So let's get the truth out there for what it is. So far as the, I like this idea of continued dialogue, but as I said, the freedmen people, a lot of people are in need. Not all of that is the fault of the tribes. Some of that is the state of Oklahoma. And there were some tribal leaders in the past that were in elected position. I think there was around 1907. There were some that were that were coming from some of the tribes that sat in Congress, that sat in the Senate, and they were opposed to persons of African ancestry. Also want to mention that the freedmen people were not citizens of the United States until the other members of the tribe became citizens. Our citizenship was coming through the treaties. Now, so that being said, I made a few suggestions about, possibly how the United States can bring some relief to the freedmen people so far as some services. I know all of that's going to cost money, but I also want to mention the fact that back in those earlier days, when the tribal governments were more limited, until the Principal Chiefs Act was passed in 1970, the Bureau, they did number people, including the freedmen people, sometimes for per capita payments. That happened, I know, in the Cherokee Nation. I know in the Creek Nation, there were some per capita payments, some relief to the freedmen people so far as some services. I know all of that's going to cost money, but I also want to mention the fact that back in those earlier days, when the tribal governments were more limited, until the Principal Chiefs Act was passed in 1970, the Bureau, they did number people, including the freedmen people, sometimes for per capita payments. That happened, I know, in the Cherokee Nation. I know in the Creek Nation, there were some per capita payments in the past. And so this sort of thing can be done, but again, it's going to cost some money. I get that. In my 22-page report,
The United States has no problem with money. We have millions of refugees at the current time crossing onto the border, and we are overwhelmingly happy to take care of them, including people from Ukraine, Afghanistan, and China. So there's money.
I have some other suggestions there. Again, we couldn't get to in the 5 minutes. So that's what I'm thinking. It's going to take some time, some effort by the federal government. I would like to, and I understand that there were constitutions that were approved by the federal government, but if freedmen people weren't allowed to vote on them, well, again, they've been signed. So there we are.
Thank you very much. I'll thank all of the testifiers as well as our first panelist, Chair Waters from the U.S. House of Representatives. The hearing record will be open for 1 month to allow ample time for views to be submitted for the committee's consideration. I want to thank all of the witnesses for their time and their testimony today.
All right. Thank you for watching this with me, and I'll see you next time.